The Hague Convention on Child Abduction becomes relevant when we're talking about, one, two countries that have signed on to the convention. It's a different animal when one of the countries hasn't signed on to the convention. The United States is a treaty partner to the convention. There are 90 plus countries that are. So that's the first issue. Second issue is that there's arguably a place where the child has resided, that generally is a place where the child has resided, and that child has been taken from where it has resided to somewhere else, again, that is a Hague treaty partner. And the left behind parent is what we call the parent that is still in the place where arguably the child has resided, is saying, I want the child back in my home country. Importantly, the Hague Convention mostly is not a custodial treaty. It is a jurisdictional treaty. All it's designed to do is decide which country is best situated to make a custody decision about that child. At the end of a Hague Convention case, you do not have a custody decision. You just have a decision about the United States would be more appropriate to decide custody of this child, or fill in the blank. England is the more appropriate place to decide custody of this child. The convention works well to protect left behind parents. First of all, the argument is that the child is a habitual resident of the left behind country, right? And there are elements that go to show that that is true, how involved the child has been in that community, how long they've been there, that sort of thing. It also protects left behind parents with a caveat. If the parent has a right of custody, so the parent needs to be cognizant of what are their rights of custody. There are a few countries in the world that have something called ne-exeat rights. Argentina comes to mind, Norway comes to mind, where a parent might have nothing else, right? Let's say the parties weren't married. There's no statute in the country that says a putative father has rights of custody. Nothing else more than saying, if you allege that you are a parent of that child, the father of that child, you have a right to decide where that child resides, what country that child resides in. And that's no-exit, ne-exeat. So a parent needs to have, the left behind parent needs to have some right of custody. And the left behind parent needs to be exercising that right of custody. If you've got those three elements, that the child's been residing there for some period of time, that you have some right of custody, that you've been exercising those rights of custody, you've got pretty good protection under the convention to seek the return of your child. The process for filing a Hague application is relatively simple. Also, to my mind, it's largely irrelevant. In each treaty, there's a governmental agency responsible for implementing and enforcing that treaty. We call it central authority. And so the application is to be filed with the central authority. And basically, it's a complaint to a state agency. In the United States, it's the Department of State Office of Children's Issues. And so you lay out basically your case. My child's been taken and my child needs to be returned. I think it's largely irrelevant because it notifies the central authority, but it has no teeth. It does very little otherwise. The key element here is that you want to do something that has teeth, which is not file an application, but file a case. You want to file a case within the relevant court, which in the United States is almost always federal court, as quickly as you can. And there's important reasons to do that. So my advice is don't focus on filing with the central authority. Focus on hiring an attorney and getting your case filed as quickly as possible. There are some limitations to the convention. There are 90 plus countries that have signed on to the convention. So there are almost 200 countries in the world. So half of the countries in the world have the convention. One of the limitations then is that there are half the countries in the world that don't have the convention, and you have to rely on some other method to be able to seek return of the children. The chief purpose for the convention also can be its limitation, and that is to prevent home cooking. It's a natural inclination for a judge, wherever they're sitting, to think that wherever they're sitting is the best place in the whole world. And so that leads toward an unmistakable and easy to identify bias. Well, why should a child ever be taken from here? They're living in the best place in the world. And so the convention seeks to remedy that by laying out pretty clear terms about determining custody. They're pretty clear terms, but again, as an agreement between 90 plus nations, there are terms that are left open to local interpretation because the countries couldn't agree on how to interpret those terms. A good example of that is a fundamental term, which is habitual residence. For example, in England, there are cases that talk about a child becomes a habitual resident of England, providing the parties have decided to relocate as soon as the plane touches down on the tarmac, right? So it's instantaneous. That's one of the few countries that makes such a determination so quick. Others look for more permanency in deciding habitual residence. So while the convention seeks to get rid of home cooking through natural bias, it still has a fair bit of home cooking, understandably, unavoidably, and unfortunately built into the convention. If you are facing a situation where your child has been removed, or where you have removed the child and you're facing some complaint that you've removed the child, whether it's to a Hague Convention country or not, give us a call. Give us a call immediately. Let us help. Let us help you protect and accomplish what it is you seek to accomplish.